that this bill be now read a second time. I call the member for Balmain.
Tricky.
It's tricky. Good evening, Mr. Temporary Speaker. Thank you very much for allowing me to take the call. Energy Legislation Amendment, National Energy Retail Law Bill, I'll be speaking to this evening. And we do not oppose this legislation, but we wanted to raise a number of issues. We wanted to raise a number of issues which we'd appreciate if the Minister was able to respond to in the address and reply. And these issues are issues which go to the heart of existing consumer protection arrangements. And members opposite have been concerned about the carbon pricing, and I understand that they raise those issues, but these are genuine questions about protections, consumer protections, which will be taken away under this proposal, and it needs to be addressed by the government. So I asked if these can be addressed, and I will go through some of these issues because the Minister's speech and throughout the material in relation to the implementation of the NEFC, there's a stated commitment by the government, which is a genuine one, that the government should ensure there's no erosion to the integrity of the existing consumer protection arrangements in New South Wales. Now, I've spent some time to look at some of the submissions to the New South Wales Trade and Investment September 2010 policy paper for consultation. That was the basis of the negotiations around COAG, and it's something which the government received significant consultation about. There are a number of concerns raised by key stakeholders, particularly from consumer groups, and I'd appreciate if the Minister could address whether those issues that were raised, in particular around the 2011 policy consultation discussion, have been dealt with. The groups I refer to in particular that raised concerns were the Energy and Water Ombudsman, the Park and Village Services, as well as the Public Interest Advocacy Centre. Most of their concerns centre around the New South Wales Government's commitment, as I mentioned, to the adoption of these laws. That their view is that these laws should not seek to erode the integrity of the existing New South Wales consumer protections. It appears that some of these concerns have in part been addressed by the government, in that many existing protections are maintained in a transition period until June 2013, but only until June 2013. After June 2013, the existing protections, I understand it, will not be applicable. And I would like to turn specifically to those. The Energy and Water Ombudsman in New South Wales, in their submission, it said that E1 is, as you know, the approved independent dispute resolution mechanism for customers of electricity and gas providers in New South Wales and in some water providers. Basically, their submission points forward that they consider there's 4 areas where the introduction of the NECF will see significant consumer detriment that will be at odds with the hardship provisions of the NECF. Number 1, the removal of the current protections around the imposition of late fees. Number 2, the introduction of a shortened collection cycle. Number 3, the removal of the post-disconnection notice, and the removal of the limit of 10 days to rectify a disconnection, which, if introduced, will further compound the effect of the shortened collection cycle and a lack of disconnection notice. So I respectfully ask if the Minister could address that. Will any of these provisions apply after the 2013 transition period? I think if you have a look at that submission, you'll see that the Energy and Water Ombudsman is genuinely concerned that if these provisions are removed after the transition period, that it will lead to a reduction in consumer protection. Now, I would appreciate if the Minister could inform the House as to whether or not these matters will be dealt with beyond the June 2013 transition period. I'd also like to raise the issues that the Public Interest Advocacy Centre raised to see whether these issues have been dealt with. And as I said, they may well have been dealt with in substance, but I just request that the Minister emphasise this. This comes to the small business operator threshold. We know small businesses in particular are in many ways doing it tough, and we know that the PIAC submission outlined, quote, that the application of the NECF threshold on small business operators will diminish the consumer protections available to some business owners, end quote. So small customers are defined in the bill as households or small businesses which consume less than 100 megawatts electricity or 1 terajoule of gas per year. So New South Wales will retain its current definition of 160 megawatts until at least 2013. Now, will that 160 megawatt definition be maintained after 2013? It's clear that that definition is one that enhances the position of small business, and if that is removed, I'd like to understand, if I may, the reasons why the Minister has taken that decision. Secondly, when it comes to fees, we know that, of course, late payment fees are not regulated under the NECF, and we know that in the submission, PIAC concurred with Industry and Investment New South Wales to maintain the regulated late fees for customers of standard retailers as per the IPART pricing decisions until 2013. The question is, will those protections that New South Wales consumers have from unrestricted late fees be applied after 2013? We know that 2013 is the date when those provisions will apply, but will there be protection after 2013? Because the application of uncapped late fees from 2013 would represent a deterioration, in my view, and I think in most people's views, of the existing consumer protections in New South Wales, and would thus be contrary to the New South Wales Government's commitment to safeguard these protections. There is a view that Industry and Investment put forward. They contended that the NECF provisions regarding late payment fee waivers are equivalent to New South Wales' existing arrangements, but there have been submissions highlighting that the difficulty in identifying and contacting customers experiencing financial hardship means that the application of the NECF late payment fee waiver is alone unlikely to represent as strong a protection as is currently available under the existing New South Wales framework. And there have been concerns raised that this lack of regulations may well see New South Wales electricity consumers who are currently protected by the regulated charge for gas and regulated lack of charge for electricity worse off. As I've mentioned, the collection cycles, the NECF provides for the introduction of a shortened collection cycle for customers experiencing difficulty with the payment of bills. Now, there's been indications that the Industry and Investment New South Wales indicated they were unaware of any evidence of the impact of the shortened collection cycle provision on customers experiencing payment difficulties or the number of disconnections in two states, Victoria and South Australia, where shortened collection cycles are currently enforced. We know that PIAC submitted that the absence of the awareness of the existence of evidence in these two states that have different collection provisions than proposed under the NECF is not evidence that the application of shortened cycles won't erode consumer protection safety. That's something I'd appreciate if the Minister could address, because we know that the implementation of the shortened collection cycles during the energy pricing period that the proposal not to, I should say, Mr Temporary Speaker, not to implement the shortened cycle during the current New South Wales energy pricing period will only go to 2013. Will they be extended? And you can see, Mr Temporary Speaker, the theme of the questions that I'm asking the Minister is that if these protections are extended until 2013, we understand they're legitimately being implemented. What are the reasons for those protections not being extended past those dates? Mr Temporary Speaker, two final points. The advance notification of variation of prices under market retail contracts. Industry Investment in the 2010-11 paper proposes to abandon the New South Wales provision that obliges energy retailers to notify customers of upcoming price variations in newspapers and on their websites. And in the case of customers on standard contracts, and via individual notification in writing in the case of customers on market contracts. Seems to be a fair thing to do. Instead, under the NECF, retailers will be able to comply with obligations to notify customers about tariff changes via a term in the customer contract, something I'm sure none of us, despite our keenness, would read. I note that in Victoria and South Australia, they are not required to give prior notification of price changes via newspapers or individual communication, but both New South Wales and Queensland retailers are required to do so. So that question, Mr Temporary Speaker, about notification, advance notification of variation in prices under market retail contracts is something I'd respectfully ask the Minister to give us, the House, some information on. Finally, can I just raise some concerns which were expressed by the Park and Village Services, which operate under the auspices of the Combined Pensioners and Superannuants Association of New South Wales, and convenes the New South Wales Residential Parks Forum, which comprises of representatives from park residents groups throughout the state, Aboriginal Tenancy Advice Services, legal aid and community workers. Two very specific questions. First of all, that the framework should not allow an exempt supplier to charge a resident the full service availability charges unless the amount is linked to the number of amps the resident is supplied. That's an issue in a lot of these facilities, that there's not sufficient ampage provided, so why should those charges, full service charges, be paid? That's a question to the Minister, if I may. And finally, where the exempt supplier is also the landlord of the consumer, disconnection should not be allowed unless the Consumer, Trader and Tenancy Tribunal has made an order permitting the disconnection. The NECF should not proceed without the current protections provided around this issue, and they're obviously quite significant when the exempt supplier is also the landlord. So, Mr Temporary Speaker, I thank the House for listening to these matters that we raised. I understand some of these may well have been addressed by the Minister, because I know there has been a great deal of discussion and consultation on this, but I would appreciate it if in reply the Minister was able to address some of these questions. I think that the consumer organisations that raise them have legitimate concerns, and I support the bill, but look forward to details of some of these questions raised being addressed in the House. Thank you.
Before the questions